My name is Pat Hughes. I am the president of the Liberty Justice Center, which is a project of the Illinois Policy Institute, nonprofit, free market think tank, in my opinion, the best one in the country. And the Liberty Justice Center was founded by myself, a gentleman named John Tillman, who is the CEO of the Illinois Policy Institute, and another gentleman named Dan Proft, who is a political person. He's a radio show host on WIND 560. And we founded Liberty Justice Center as part of a network of entities to try to change the political and policy culture in the state of Illinois. The Illinois Policy Institute was already in place, and we wanted to expand that. And the goal of the Liberty Justice Center is to make sure that government, as it relates to free markets and economic liberty, stays out of the lives of individual citizens as best we can. This book was conceived, and I have to give credit to a dear friend of mine, a board member at Illinois Policy Institute, and a tremendous supporter of the work that we do, Mr. Ed Bachrach, who's here joining us today. Ed conceived the idea that the Illinois Constitution was a major part of the structural problem that plagues Illinois politics, that it's not just Mike Madigan or Bruce Runner banging heads. It's not just ideas that are different between public sector unions and private businesses, but the actual structure of how our state is organized politically, and the Constitution is not a Constitution that's appropriate for the 21st century. So Ed asked me to lead an effort to produce this book and to start the process of promoting it and getting the ideas that are contained in this book out to the public. And this is our first venture, and so we're so grateful that you're all here with us today to start this process. I want to introduce just quickly a few people. Jacob Hubert is the senior attorney at Liberty Justice Center. He guided the process of the book and made this all possible along with his staff. Jeff Schwab, Joe Tabor, and James McQuaid, all who are here today, and whom without we wouldn't have this great book, and of course our support we receive from all the folks at the Illinois Policy Institute and our great authors, including our three panelists that are here today. So thank you for being here. Without any further ado, I'd like to introduce Jacob Hubert, the senior attorney of Liberty Justice Center.
Thank you. So I'll just tell you briefly about our book and then about our speakers here today, and then let them get on with the rest of the program. The book proposes reforms to many facets of the Illinois Constitution, both the provisions that are intended to protect individual rights and the provisions that govern the structure of government. Reforms are necessary in all of these areas to ensure that the Constitution serves the purpose that the previous Constitution, our existing Constitution, was supposed to serve. And that is to ensure that government doesn't pick favorites, doesn't pick winners and losers in politics and the marketplace. That was the theoretical intention behind much of our 1970 Constitution. But that's not how it's played out at all. In fact, we know that the Illinois state government and our Chicago government is very much in the business of rigging the political game, rigging the marketplace to favor certain people who are well connected to the political establishment. And these are the types of things that the state legislature could theoretically address through legislation, but which we really should enshrine in the Constitution so that we have the actual protection, long-term protection for people's rights that we should have. And so you'll see in the first few chapters, we talk about particular areas of rights: economic liberty, religious liberty, eminent domain, where of course famously people do not get the protection that a lot of people think that they should have. And then we get into chapters on the structure of government. For example, a chapter on term limits, a chapter on redistricting reform. These are both things that Illinois voters have overwhelmingly indicated that they want. And they've tried again and again to put on the ballot through citizen initiative. But the political establishment in the state consistently brings lawsuits to kick those things off the ballot. The Illinois Supreme Court has said that citizens can't put those things on the ballot, and as a result, we're just stuck with a political establishment that keeps itself in power by skewing the law to favor itself at everybody else's expense. And there's chapters on sunsetting legislation so that things don't become unduly entrenched that way, judicial selection. There's a provision in our Constitution that says that all laws have to serve a public purpose. which seems reasonable, and which again was a major theme behind the Constitution, that laws should be designed to serve the public, not particular private interests. But that is proven to be not a very good protection against legislation that benefits some private parties over others. And so our chapter on that was written by Clint Bolick, a justice of the Arizona Supreme Court. We also have chapters on pro-growth reforms, like a balanced budget amendment. We have one. It doesn't actually do much of anything as it exists. We have a chapter on Illinois' pension problem, which anyone at all familiar with Illinois politics presumably knows about. We have a Supreme Court that said you can't really do much about pension reform, so we have a chapter that says, well, here's how you can amend the Constitution, or maybe have federal legislation that can address that problem. And finally, there's a chapter on how you amend the Constitution. Illinois citizens can barely put anything on the Constitution. They can't, in some states, citizens can put any kind of constitutional amendment on the ballot. In Illinois, they can do virtually nothing, and as a result, it's very hard to get the kind of reforms that we need. So our speakers here today are going to address 3 topics in particular. Our first speaker is Professor Richard Epstein, familiar to many of you, I'm sure. He's the Lawrence A. Tisch Professor of Law at the New York University School of Law and senior lecturer here at the law school. He's an expert on many legal topics, from torts to contracts to property, just to name a few. And he's the author of many books, for example, Takings, Private Property and the Power of Eminent Domain, Simple Rules for a Complex World, and the Classical Liberal Constitution. I should also let you know that in addition to his scholarly work, he has a weekly podcast called The Libertarian, which addresses all manner of issues of the day, and I recommend that to you. He'll be speaking first about the project of the whole, about this project as a whole, and then a little later about the issue of pensions in particular. Our second speaker will be Timothy Sandifer. He's Vice President for Litigation at the Goldwater Institute, which is based in Phoenix. He does litigation to advance particularly economic liberty and private property rights. He's brought many lawsuits and been successful in many lawsuits to advance economic liberty, including lawsuits in California, Kentucky, Missouri, Oregon, and other states. He's the author of 4 books, including, for example, the most recent one, The Permission Society, How the Ruling Class Turns Our Freedoms into Privileges and What We Can Do About It. The cornerstone of liberty, property rights in the 21st century America, which he co-authored with Christina Sandifer, and the right to earn a living, economic freedom, and the law. Our third panelist is Professor Robin Fretwell Wilson. She's the Roger and Stephanie Jocelyn Professor of Law at the University of Illinois College of Law. She directs the college's Family Law and Policy Program and the college's Epstein Health Law and Policy Program. She's the author, co-author, or editor of 7 books, including, for example, Same-Sex Marriage and Religious Liberty, Domestic Relations Cases and Materials, and Understanding Family Law. She's worked extensively on state law reform efforts, including recently in Utah, she helped state legislators pass legislation, anti-discrimination legislation, that balances religious liberty with LGBT rights. So after they speak, we'll have some time for questions and answers. But for now, I will turn it over to them, beginning with Professor Epstein.
Yes, well, time is of the essence, and so I will be uncharacteristically brief, at least in my original remarks. First of all, I'd like to thank Jacob for inviting me and for asking me to write the preface for this book. The man has to be sound because he was one of my more distinguished Roman law students, and as we all know, that is one of the major prerequisites for anybody to assume a position in serious modern policy issues today. But what I want to do is to actually talk very briefly about the tensions that are implicit in the way in which we describe our particular project. There is no question that the Illinois Policy Institute and all of its subdivisions are, in fact, very strongly pro-market. And indeed, I am a regular recipient of their weekly broadcast and blast, and unlike most things, I actually read them because I always learn something from them. But the great tension is, if you wish to defend markets, you have to deal in non-market institutions and to figure out how these things are put together. If you want to take the sort of hardline anarcho-libertarian position that says we don't want any government, we don't want any taxes, we don't want any nothing whatsoever, then what happened is your prescription is very short. let's abolish everything, and you have a 2-page book which nobody will read. If you listen to what the titles were in all of these particular areas, the book has a much more subtle and powerful message. And that is, if you're trying to figure out where things go wrong, it's not in the operation of the competitive system, it's in the infrastructure and institutional arrangements on which this thing in some sense has to rest. And so virtually every topic that was mentioned in this area does not deal with how markets work. They work just fine, thank you. It deals with the question of how the government comes on them by a system in 2 ways. One, by various forms of regulation, whether it be of religious liberty or property rights or taxation and so forth, and then by the choice of institutions that we have in order to make sure that these various activities are going to be done either correctly or incorrectly. I think it's fair to say that in general I'm a great fan of separation of powers, but until very recently with the election of Bruce Lawman, a separation of powers was not a powerful force because all great minds in the state of Illinois thought the way Mike Madigan thought, which is in my view a recipe for long-term disaster in how things go. So what the panel is going to do, the 3 of us who are here, is we're going to pick 3 of the chapters. The first chapter that Tim's going to talk about is essentially, I love his title, so I'm going to actually quote it to you. It's the patrimony of the poor man, indicating that economic liberties are not some basic protection for the privileged, the rich, and the wealthy, but exactly the converse is true. These rich guys can protect themselves through litigation, or rather through legislation and litigation. Markets are needed to protect little people who cannot protect themselves through the political process, given their lack of resources. And then it turns out that Robin Wilson is going to start to talk about the religious issues on, again, the title is expression form, harmonizing religious exercise and legitimate government concerns. This is not the words of somebody who's frothing at the mouth about how things ought to be done. And then at the end of all this, what I will do is I will transmogrify myself, and Diana first got Roth, an old friend who can't be here today, and I'm going to talk about empowering Illinois' pension law reform, which is a topic that needs it. Since we do want to leave time for questions and so forth, and we have only 50 minutes left, I would ask each of the panelists, that includes myself, to speak between 12 and 13 minutes, right? Not 12, so that we can leave time for questions that do take place. And Tim, you're up.
Thank you very much. Well, my chapter in the book focuses on economic liberty. I regard economic liberty as America's most neglected civil right. It's a fundamental right of all human beings to be able to without interference from others or from the state, use their skills to provide for themselves and their families and possibly create a large fortune if they are hard enough at it, if they work hard enough at it, and if they're clever enough at what they do. That right was well respected and recognized by Anglo-American common law courts as far back as Shakespeare's day and even farther back than that, under this tradition that we today call substantive due process, but back in the day was called due process. And this strong protection of the right to earn a living is found in the history of Illinois law as well. In the chapter, I point to a particularly fun case from 1851 called Gales versus Anderson, in which it was basically a miniature version of the Charles River Bridge case. There was an existing ferry that had a charter, and then the government created a new ferry by giving it a charter, and the existing ferry objected that this new ferry was going to interfere with their existing monopoly, and they took it to court, and the court ruled against them and said, no, the free competition is constitutionally protected. It's a fundamental right to use your skills as you wish to provide for yourself and your family, and it's good policy, by the way. A wonderful line from that case is where it discusses how, in the great deal of time that it took for the case to be adjudicated, the existing ferry had improved its services as a result of the competition of the new ferry, or, as the court put it, the stimulating influence of rivalry. We see this exact same argument playing out today in the fight between existing established taxi cab monopolies and Uber, to name just one example of how the existing industries like to prevent competition in order to secure their own private interests. In 1867, the Illinois Supreme Court decided a case called Chicago versus Rumpf, which is kind of a miniature version of the slaughterhouse cases, in which the city decided to regulate the slaughtering industry, not by passing rules prohibiting nuisances and protecting public health, but by granting a private monopoly to a single corporation to carry on the slaughtering trade. And the Illinois Supreme Court, unlike the US Supreme Court, struck that down and said, yes, the government can regulate in order to protect the public safety, but it can't hand out special favors to particular classes. That's why the Illinois Supreme Court, quoting Adam Smith, referred to economic freedom as the patrimony of the poor man. The wealthy man's patrimony is, the inheritance that he gets from great-granddad. But the poor man's patrimony is in the skill and labor of his hands, and the hard work that allows him to build up a fortune for himself if he works hard enough at it in a free economy that doesn't have political favors being used for economic benefit. Unfortunately, the Illinois courts turned away from the protection of that right, as many state and federal courts did in the era following the New Deal. In 1934, the U.S. Supreme Court created a new constitutional test called the rational basis test. And under this test, a law is considered to be constitutional if it is rationally related to a legitimate government interest. Here's the audience participation part of the test today. What is a legitimate government interest? That's correct. Nobody knows. In 1987, in Nolan versus California Coastal Commission, the Supreme Court said, our cases have not laid out the standards for determining what is a legitimate government interest. Well, if you don't know what a legitimate government interest is, how do you know whether something's rationally related to it? The answer is you don't. And so basically, whenever a law is challenged under the rational basis test, the courts uphold it. Now, that was a federal test created by the Supreme Court in 1934 to apply in due process cases. But the Illinois courts have adopted it to apply to state constitutional issues involving clauses that have nothing to do with the due process clause of the 5th and 14th Amendments of the U.S. Constitution. In 1974, in a case called People versus Patton, the Illinois Supreme Court upheld a law that prohibited ticket scalping. And the reason this is relevant is because an earlier court opinion from 1907, the Illinois Supreme Court had struck down a law against ticket scalping, citing economic liberty and saying that to prohibit people from reselling theater tickets was an arbitrary interference with their private property and their economic freedom. But this time around, the Illinois Supreme Court upheld the law, and it cited the rational basis test from Nebbia and said, well, all that stuff about economic freedom from the past, we don't believe in that anymore because of the new rational basis regime. This is an example of what I think is a real problem throughout the country, including in Illinois, where state court judges basically just imbibe federal jurisprudence, often from not only the wrong jurisdiction, but from the wrong era. Sometimes a state court interpreting a constitution written in 1970, or in California's case, 1878, will use federal jurisprudence that was written in the 1950s or the 1970s or the 1990s. A clause that refers to clauses that have nothing to do with the case that's in front of that court. Now, the Illinois Supreme Court has given a test for when it should simply follow in lockstep federal jurisprudence on some issue, and when it should apply its own independent judgment, in a case called People versus Cabela's just a few years ago. The problem is that case ignores some of the most important reasons why state judges should interpret state constitutions in accordance with state values, state history, and state mores. One of them is that following federal precedent overlooks the fact that much of this federal precedent is created self-consciously in order to maximize state autonomy. Federal judges will say, well, I don't want to interpret this clause too strictly because we want to leave the states free to do such and such. So for a state judge then to follow lockstep what that federal court has said is basically to expand state jurisprudence or state power even more broadly, right? State clauses often depend on the culture and history of that state in a very crucial way. I was at a conference in New York, last year, the year before. The judge said, well, I don't think it makes any sense to say that there's a difference between the New Jersey Constitution and the New York Constitution when their language is the same, because it's basically the same people. And you can't say that there's a difference between a New York soul and a New Jersey soul. And I had to object that there's a great deal of difference between a New York soul and an Arizona soul. Right? We have the history of the gunslinging independence of the Old West in Arizona. That's very different from the political culture and history of East Coast states like Massachusetts and New York. What about chronology? I mentioned this before. A lot of the time the federal court opinions that these state courts follow are not in chronological, that makes no chronological sense to follow them. And there was a case in Alabama, I think it was, a few years ago, where one judge pointed this out. He said the current Alabama Constitution was written at a time when the Lochner doctrine of strong protection for economic liberty was the law of the land. If we're going to interpret our state constitution, we should follow that doctrine. We shouldn't follow a doctrine that came along 30 years after our state constitution was even written. Also, even where a clause in a state constitution mirrors the federal constitution, there are other provisions in a state constitution that interact with that don't. So, for example, Minnesota has 2 due process clauses in its constitution. What sense does it make to follow federal due process jurisprudence in a state where the state constitution has 2 different due process clauses? New York has a due process clause and a law of the land clause, even though most lawyers read those as being synonymous. How sensible is it to follow federal jurisprudence here? Missouri has 5 separate constitutional clauses governing eminent domain. How do you follow the Kelo decision or something if you're applying state law about eminent domain in a state that has 5 different provisions? Citizens expect and have a right to have their state judges use their own independent judgment, especially in states where judges are elected. It's wrong for state judges to say, well, I'm just going to follow what the federal courts have developed. I think it's also intellectually lazy. It's surprising how many of these opinions you read where state judges make no effort to look into the history of their state constitution. I'm going to ding California a little bit on this. California courts have been so-so when it comes to the history of their own constitution. But if you try and look up the history of the California Constitution, it's rather difficult. The debates at the Constitutional Convention of 1878 were printed one time in 1880, are not available online, and are virtually impossible to use because the index isn't even in alphabetical order. The California Constitution is an embarrassment, so I don't necessarily blame them. But if you're going to interpret the state constitution, you really should look into the history of that state's constitution and why it was written. The Western states in particular had experience with exploitation by railroad corporations that would come in and use political power to get their way, to exclude competition, to steal land from people through eminent domain for their own private gain, and Western constitutional conventions took this all into account when they wrote their constitutional provisions. For them to follow lockstep federal jurisprudence that addresses totally different issues makes no sense. We have it in our hands in the form of state constitutions to protect individual rights more broadly than the federal constitution does. That's basically what they're for. And we have those tools at our command, if only we'll take advantage of them. But that does require hard intellectual work. And in my opinion, this book is a first step toward making that intellectual work a reality. Thank you.
On time. One of the dominant notions for all sessions of this sort is the notion of a temporal taking, which comes out of the doctrine of the states. And when somebody does not do it, I give him a benevolent smile that leaves more time for me and for Robin.
Well, so to start, I just want to thank Jacob, Jeffrey. I want to thank my co-author, Heidi Brady. And I want to talk a little bit about religious freedom in Illinois. I also want to bracket for just a second that we're experiencing an adhesion contract because I was actually told that I had more time. So when you see that cutoff, just realize that we had a new temporal limitation implied.
You can go to
Okay.
12:56.
Thank you. I appreciate that. Not that it did much good negotiating. But in any event, so what would a 21st century constitution for Illinois look like when it comes to religious freedom? That's a question that we were asked to address. Now, I think Americans tend to constitutionalize everything. We think that the Constitution certainly protects those things that are most core to us. But in this context, for a complicated set of reasons that I'll talk about, putting our emphasis on the Illinois Constitution, or for that matter, the U.S. Constitution, to protect people of faith from an encroaching government and set of duties is going to pay little dividends. And to understand why, I want to look at 3 different ways that we protect religious freedom in the United States. I'm going to look at constitutional protections, and then I'm going to skip to the things that are most important. the kinds of statutes that actually pay dividends to people of faith. And those are generalized protections. You've heard of RFRA, also the inartfully named RLUIPA, the Religious Land Use and Institutionalized Persons Act. Those are examples of generalized protections for religious freedom. And then I'm going to talk about something that I think are more surgical. There are protections, specific statutory protections for religious freedom. You have them in Illinois, for example, in its new same-sex marriage law. So let me start with constitutional protections. And here's the Illinois constitutional protection itself, Section 3. And it says, and it would appear to be broader than the First Amendment to the U.S. Constitution, the free exercise and enjoyment of religious profession and worship without discrimination shall be forever guaranteed. Whoop, game over. That looks like you would have protections for those kinds of things, even in the world, and not just for worship. But Illinois, as Tim already said, uses this sort of lockstep doctrine, which makes Section 3 coextensive with the First Amendment to the United States. And that, in fact, is where the problem is going to come, because the constitutional protections in Illinois are only as robust as those in the U.S. Constitution, and those have been significantly dialed down. Now, at one time, they were dialed down in the famous Peyote case, but at one time, the United States Supreme Court used something that looked like strict scrutiny, the highest level of review, the most exacting review of the government, to decide when a burden unnecessarily encroached on religious faith or practice. And so they would ask at that time whether that burden was necessary, whether there was a less restrictive way to accomplish the state's goals. But in Employment Division versus Smith, Justice Scalia said that protective approach is wholly unworkable. It would make every religious believer, he said, a law unto themselves. Now, he makes a fair point. I'm going to come back and explain how this took us to RFRA. But he makes a fair point, because it is really hard to follow this strict scrutiny in the world. And I'll give you some examples. Hobby Lobby, for example. If you followed that, you might come very quickly to the conclusion, to hell with Hobby Lobby's women employees. They don't need contraceptives. As an aside, that's not actually what happened. We'll see that the Obama administration found a way to protect religious beliefs of, for example, nonprofit universities like Catholic University or Georgetown or another, and make sure that those women receive those contraceptives from someone else, not from that employer, from an insurer. Nobody likes insurers overmuch, and so that didn't seem to be a great problem. Or it would mean, for example, does everybody recognize Kim Davis from her mugshot, right? She shut down marriage to everyone in a part of Kentucky, claiming that her religious conscience allowed that result. Judge David Bunning broke that impasse by tossing her in jail and telling her employees that they would marry people in Rowan, Kentucky, meaning gay, straight, black, white, anybody, or they would be thrown in jail too. And that actually shows you that you can have protection for religious belief. We can staff around a Kim Davis as long as that work still gets done. But if you only have strict scrutiny to work with, sometimes it doesn't make you contextualize and find ways to balance those competing rights. It only gives you win-lose answers. Now, you can see from these examples that there's merit to Scalia's basic concern that if religious people win over every other value in society, at some point society's other commitments become hard to achieve, like our commitment to equality in the gay rights context. So Scalia created a new standard. He basically said that valid neutral laws of general applicability would not offend free exercise guarantees. Many people were disappointed with Scalia for that because they feel like Smith backwalked the kind of primacy of religious freedom that they thought was there in the U.S. Constitution. But, and here's the key, Scalia, in the white quote here, specifically invited legislatures to show the state's special solicitude for religious freedom in statute. And Congress took up that invitation in the Religious Freedom Restoration Act, which passed in '93. Obama was not present during that time. I'll come back to that in a second. But passed in '93 to overwhelming bipartisan support. Clinton signed it into law. Now, RFRA goes back to that pre-Smith era. It actually has a kind of heightened scrutiny that the government has to show proof when it substantially burdens religious belief to show that, yeah, there was a compelling reason for doing that, and there was no less restrictive way to do it. So RFRA took us back to where people believed we were before the Smith decision. Now, like RFRA, we also have the Religious Land Use and Institutionalized Persons Act. Let me say, by the way, that Illinois is sort of where the rest of the country is. Most of the rest of the country. Few states in their constitution impress this heightened standard. Instead, they have a RFRA, like Illinois and lots of the country has right now. Now, the Illinois Religious Freedom Restoration Act, in that debate, President Obama, who was then a senator, actually raised the hardest question. He said, what will happen with the state's anti-discrimination civil rights protections if we pass a RFRA? And the Senate debate suggested that that would not, in fact, encroach on the RFRA at the time. Now, you can think of these laws as kinds of belts and suspenders laws that are there to protect religious practices, to kind of use Tim's words, the little people, right? So some religious practices are so arcane that no legislature is ever going to write a specific rule for them. Think, for example, the Santerias and animal sacrifice. Some religious practices or religious communities are so small that no one's going to write a specific statute for them. Think the Sikhs and the karpans, or the little weapons that they're supposed to have on their person at all times. So what a Religious Freedom Restoration Act, or our LUPA, does is it tries to provide or backfill anytime there is an unusual question of religious belief. What should happen to that? How should we think about that as a problem? Now, one of the places where this pays dividends, and I think is what people thought was happening before Hobby Lobby, I hate when that happens to me, by the way, is that people thought that RFRA protected small religious minorities. Think the Amish. So, for example, the Amish do not want to put orange triangles on the back of their buggies at night. They consider in their faith tradition that that's flashy, so that's not okay. They would be happy to put a gray triangle on the back of their buggy. They'll put a lantern in the buggy for safety, but they don't want an orange triangle. What did Kentucky do before it adopted its RFRA? It tossed 8 of these men in jail for not having the orange triangle on the buggy. Now, most people think, you've got to be kidding me, right? There's got to be a better way to be respectful of religious belief and also achieve our safety goals. And that's the basic goal of RFRA in that case. Holt v. Hobbs is another example. In the Arlupa context, which protects religious lands, it protects prisoners in the care of the state, basically says to the government, don't step on their religious beliefs unless there's a really good reason. And in Holt v. Hobbs, the case with the Muslim beard, the state, Arkansas, had said that he would hide this razor, this exact Bic razor, in that beard. And that didn't go very well when it actually got to the U.S. Supreme Court. I'm going to play
Be honest,
a quick.
you now want to hear the entire hour-long oral argument, don't you? No. But I will give you just another taste.
Well, as far as searching the beard is concerned, why can't the prison just give the inmate a comb? He could develop whatever comb he wants and say, comb your beard. And if there's anything in there, if there's a SIM card in there, or a revolver, or anything else you think can be hidden in a half-inch beard, tiny revolver, it'll fall out.
Those
And you see the ludicrousness of the state's position sometimes. That beard was not a problem. And now he's going to be able to keep his beard as an observant person. But the key for the question for the Illinois Constitution itself is that came from statute. It did not come from the Constitution, and neither will it if Illinois' Constitution maps directly on the U.S. Constitution and nothing else changes. Now, we have a new justice on the Supreme Court. I suppose you might think that that would change over time, but I don't think, at least the religious scholars that I've been working with, think that's going to happen. Now, one of the problems with legislation, though, as a way to protect religious freedom, is that you might have a statutory protection that gets backwalked over time. That actually happened in Illinois. So the Chicago OHare Airport, it was stalled because there was a cemetery in the way. And RFRA would have said, got to go around the cemetery. unless there's a less restrictive way. So what did the Illinois legislature do? It amended RFRA to make way for the Chicago OHare Airport. And that's actually something that's deeply worrisome to people who care a lot about religious freedom, that it will just be amended to make problems go away. Now, the federal courts are split over a particular question under RFRA that actually is really important to religious believers. And that is whether RFRA could be used as a defense in a private lawsuit brought by one citizen against another. So imagine that there's a noise ordinance passed that says there can't be any noise on Sunday morning, period, full stop. So if I have a church and the state fines me, I can bring a RFRA suit, right? And I will have the protections of RFRA, and we'll decide whether there was a less compelling, a compelling interest or a less restrictive way to achieve that. But it's not clear if, for example, Professor Epstein sued me privately because he happened to have his house next to my church, whether I could use RFRA in that nuisance suit to defeat Epstein.
No.
Yes, exactly. And that's actually very disturbing for a number of people who care deeply about religious freedom. Another question that is going to be really omnipresent is the question of the baker, right? The baker, the florist, the candlestick maker. What are we going to do with anti-discrimination law? And how are we going to try to balance religious freedom rights with anti-discrimination law? And many of the state statutes that you have, like, for example, the Human Rights Act here that protects people from discrimination, they make specific allowances for religious communities now. But you can think of those specific allowances as the extent of what the state meant to do, at least before a new context arose. And so if you're not specifically protected with a statutory protection, and I'll give you an example. One statutory protection would say that religious employers can, quote, religiously discriminate. In other words, the Archdiocese of Philadelphia should be run by a Catholic. And if they only want to hire a Catholic and not an evangelical, not a Baptist, not someone else, they can do so all day long. And that would be my time. We'll stop at that point.
God, this is such a wonderful panel. Now, I'm not going to abuse the privilege. But what I want to do is to remind everybody that I'm sort of a stand-in for my friend Diana for Scott Roth. And so what I'm going to do is read the initial sentences from her rather perceptive critique of the situation in Illinois to give you some sense of the gravity of what we face here. The Illinois pension funds, which provide retirement payments for about 479,000 state employees and retirees, are insolvent. The actuarial unfunded liabilities for Illinois' pension plan stood at $111 billion for the year 2015, according to government estimates. Apparently, it hasn't shrunk since that time. The liabilities increased by more than 600% between 1999 and 2013 in nominal terms, and by more than 450% in real terms. I wish to remind most people that general wages have not gone up fourfold in the last 14 years. So clearly there is some form of massive disproportion that Diana is able to point out that has to get our particular attention. $111 billion and rising is, for example, close to 10 times the size of the bankruptcy that took place in Detroit. And right now, if you look at Puerto Rico, they are also contenders for the gold ring, having in a much smaller base a deficit of about $75 billion. So the question you want to ask is, how does this stuff arise, and what is it that you're supposed to do about it? And one of the things that's so striking about the papers that the Illinois Policy Institute has put together is we're all balancers now. When Tim starts to talk about individual liberties to enter market, it doesn't mean that you could form a market to kill people. Robin oozes balance when she's trying to figure out exactly how far religious liberties can go as against other demands of the state. And I wish to say that Diana and me are in that particular tradition. There's nobody who's coming here who wants to say, first of all, that we should have no public pensions, or B, that the appropriate way to solve this particular problem is to essentially break all pensions and to declare them invalid. But what you need to do is to first have an account as to how this problem arose, and then try to figure out what modest steps you can take in order to solve it. And the explanation for what's wrong with this in Illinois is that with virtually every other area, there's a huge amount of crony politics that takes place inside the state. And it turns out that public service unions are extremely powerful in the state of Illinois, as they are, for example, in the state of California and New York. And what they were able to do with the 1970 Constitution was to put in a provision which says that all contracts that create pension rights are inviolate with respect to anything else. So there is, in fact, a rapid disjunction between the contracts clause as it generally applies to other situations, which subjects it to a police power limitation, and this thing which not only makes these rights absolute, but gives them a first priority over every other right that you might want to imagine. If, in fact, these things were conducted on sound actuarial principles, then the protection and the priority might be respectable. But the second part of this situation is that the legislatures are, in fact, very subject to political maneuvers. I don't think it takes a great mystery to realize that the state politics have been dominated by Michael Madigan over the past years. He has very close connections with unions and other groups, and so what happens is all state legislation that you see being put forward isn't generally sympathetic with trying to grant raise after raise with respect to public workers. A reform that I would recommend is that when you look at the median wage increases in the state of Illinois in the private sector and use that as a kind of a collar that you might want to impose upon public increases, because the numbers that we are seeing here are funded on the backs of Illinois wage earners, many of whom are quite less wealthy and with less favorable pension than those that we have under this system. And then for many years what happened is the governor of the state was a Democrat. Pat Quinn was only the least. Many of these governors, as we know, ended up in places less desirable than a retirement home. And sure enough, most of them go ahead and try to fix this. Then in around 2010, 2013, the Illinois legislature comes up with a proposal which is designed to close the gap in 30 years, which means it's the next generation of people after we're dead who will pay for all of this stuff, but we can have a clean conscience on this particular matter. And as so often happens, two things take place. The moment you put this as a 30-year corrective proposal, it's going to be negated down the line by other legislative action, or the court will strike it down. And sure enough, Illinois courts have been extremely aggressive. Not only have they protected the pension piece of this, but they went out of their way to protect the health insurance piece of this thing, and have created a situation where basically most of Illinois bonds are as junk status. And so the point to make about structural protections is that if you have every branch of the government working in accordance with the wrong system, what will happen is separation of powers will not do anything. It only works when one right is green and another one is red and the other one is orange. If they're green, 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 it's as though you have a single dictator, and on this particular issue, that's exactly the way the thing has taken place. So we have a very serious problem. What is the way to do this? Well, Illinois has not tried this, but I was involved in some legislation or litigation in San Jose trying to deal with the question of an ordinance was designed to sort of prorate the reductions in the pensions in order to make sure that other essential services inside the state could survive. And so the theory was that we will reduce this as much as necessary to restore balance, but no more, and then give workers an option as to whether or not to take a reduced pension or to make additional contributions to keep things going. And given provisions parallel to those that you had in the Illinois situation, the trial judge struck this down. Chuck Reed, who was the reform mayor, was term limited out of office, and then they reached another one of these unsustainable settlements, which will put the city into that particular position. So the litigation front, I think, is going to be extremely difficult to do at the state level. And if somebody wants to try and do this at the federal level, I'm certainly prepared to help them, but I'm not taking this case, ladies and gentlemen, on a contingent fee, because I think the ability to get the federal courts to override what the state courts have done on matters dealing with essential state governance is not going to play particularly well within this system. So what Diana then tries to do is to figure out some other ways in which you might try to solve this particular problem. One of them that, of course, you could consider is to raise taxes. That's something that you could always consider. But before you consider it too deeply, remember Mr. Laffer and his famous curve. which is there comes a point which you start to raise the tax levels, you reduce the tax revenues. And Illinois, as the Illinois Policy Institute has shown time after time after time, essentially has faced the problem that its tax base is eroding because of the consistent out-migration from the state and the loss of manufacturing jobs and so forth. You want to accelerate that trend, all you have to do is to raise taxes. People will leave, and more importantly, which is something legislatures often tend to forget, is if you do that, the no welcome mat sign is out, and outsiders will not come in. And so what will happen is you will be in a situation where other people from the great state of Indiana will eat your lunch on a regular basis by having signs as you get off the bridge, which announce we run balanced budgets in this particular state. Illinois had a balanced budget in the Stone Age, but hasn't been able to do that since that particular point in time. Don't think that these messages don't have an effect. And if you look at unemployment rates, as the data from the IPI says, it's Illinois down consistently, right-to-work states are up in Indiana and so forth. And indeed, one of the things to note is union membership in Indiana is up since the right-to-work laws were passed because of the increase in the size of the manufacturing base. So the taxes are not going to work. The flat tax is an important feature. You could raise it a little, not important. But what's really ruinous in Illinois is the very high property tax structures. And I can tell you that, having been getting 10 to 15% annual increases on my own apartment in this particular city. It's not a real joke in these situations. You can't move that. And the workman's compensation premiums are way out of line. So you can't do it on the tax side. So what else can you do it? Well, what you have to do, essentially, is to do it on the benefit side. And so you've got to try to renegotiate a cram down of some sort with respect to the various unions for their various programs. This is almost impossible to achieve in many ways because there's so many different unions with so many different agendas that everybody will say, après toi. Let somebody else make the first concession. But if you don't do this, you're going to see a major meltdown inside this. And if you want the private precedent, look at the deals that took place with respect to General Motors. They had about 500,000 employees in 1979, and by the time they went bankrupt, they had lost 90+% of those employees because they simply could not sustain what was going on with their various arrangements. So one wants to sort of do this, and the only way it will work is to get everybody in the same room, lock the door, and say you are without food and water until you agree to pro rata reductions in these things, and we don't want to make any other crude adjustments because they will be killed. So that's the second thing you can do. It's not going to happen unless until I become dictator of the state, and that's not going to happen, fortunately, either. So third thing you could try to do is to wean people from the defined contribution, the defined benefit programs which they have inside this state. This may seem to many of you to be an occult point, but there are two ways in which you could fund pensions. The University of Chicago academic employees like me are members of TIAA-CREF, and what happens is, you're not part of this because you're in state pension systems. What happens is, what we do is we put an amount of money, we can figure out how we allocate it. That money is vested for us immediately. If we go to another university, it stays there. So all the financial risk of it going south rests upon us, and all the benefit of going north stays with us. And the system has proved itself remarkably stable. But most employees who are not academics are, or at least used to be, on defined benefit plans, and those are situations where what you do is you have a target that you have to pay. If the money increases in the Treasury, the state can take it back and put it into general revenues. If it goes down, you have to make the shortfall. Guess which has happened in the last 15 years when you're running these pension plans on the assumption that the appropriate rate of return is 8% compounded, roughly speaking, which is pie in the sky until very, very recently. If you look over a long period of time, it gets more complicated because you must take your money out of equities and put it into debt until once it is that people are actually built into the retirement plan, and so the gap starts working. So migrating out of this particular system for all new employees into defined contribution plans will help solve the particular problem. But the prediction that I would make is that, notwithstanding what Diana says and what I would do, the basic bottom line that we have with this particular problem is quite clear. This state will go bankrupt. the way in which Puerto Rico has gone bankrupt. There seems to be no awareness that mañana will never come. There is always the hope that some mighty industrial improvement and revival will take place. As the Illinois data shows, the outmigration from this state of capital and of labor is just enormous, so those of us who stay behind are very much at risk. This is a classic illustration of how it is that you create a failed state. And if people think that that's the way in which you would like the world to operate, then you should ignore everything that is contained in this book. If you're trying to figure out that we would like to do a little bit better than Puerto Rico and Somalia, then in effect, you have to think about serious, major structural reform. Now, I am not a despot. I'm just a crank. And so therefore, having done my 13 and a half minutes, I will now open the floor to questions on the following ironclad stipulation. I am a dictator. You will ask short questions. Our panels will give short answers. And hopefully we could get some intelligent stuff in the next few minutes. Yes, sir.
Hold on. With the dictator's permission, I have one thing to add. If the panelists, whoever is answering, could repeat back the question so that it's picked up by the microphones and the online audience could hear it, that would be great.
Well, I'll repeat the question and the panelists can answer them. Yes, sir.
I assume that you're talking about a constitutional convention that's going to change our constitution, and my question is, how long a process are we looking at before we actually implode?
Well, the question is, are we looking at a constitutional convention to change this process? How long will it take? And will we implode? Panelists?
Well, I'll say what cannot be sustained won't be sustained. So the implosion that's been predicted so dolefully here seems likely. $111 billion. That's
2015.
That's the GDP of Mississippi. You could give them Mississippi, and then they will have been paid off. That's incredible. But as for the particular process of calling a constitutional convention, well, it begins with a popular call for it, and I haven't seen any such thing.
You're just, on religious freedom, there's no percentage unless you change the Smith decision, right? Or you change your decision to march lockstep to it. I mean, I suppose that's one way.
Look, I think the answer is that the process is long, and that the only way it will take place is with basically electoral rebellion by the popular. Vote the rascals out is fine. I've always been a firm believer in term limits as a political construct. Basically dislike the libertarian approach, which says 3 in the Assembly and 2 in the Senate or whatever it is. I think you need longer terms, but what I do is I ask myself, how many of the power brokers inside this state would still be in office if you had a 20-year term limit in the House of Representatives? And the answer is they would all be gone. So I think that that's one way in which you would try to do this. If Lisa Madigan becomes government, forget about it. Because at this point you would have a spectacle, right, of the governor being the daughter of the assembly leader. This starts to look like Argentina. It doesn't start to look like a serious republic. Next question, sir.
You offer compelling arguments for achieving structural reform to address these problems. We have a finite number of ways to amend the Constitution, a couple of which have been mentioned. We have an automatic con consideration every 20 years in our Constitution, citizen initiative, and getting the General Assembly to put something
Come up on the panel.
Put something on. My question is, which of the available methods of amending our Constitution and some of the ways suggested in this book would you suggest that we try to pursue? They all seem equally unlikely.
Well, they're all unlikely, but essentially, if you remember when they had the ratifying conventions, they didn't go back to the state legislatures. They went back to independently jerry-built conventions of the federal Constitution. I would think that a citizen's initiative would probably hold the strongest possibility because it would get you out of the legislative situation. That's just a guess. I'm not an Illinois politician. I simply work in the stratosphere of deep and profound thoughts. But I'm quite willing to descend down in any way that will help this thing because we have put ourselves into a situation where all the vectors are pointing in the wrong
Remember,
direction.
this is not the first time.
They've got nowhere.
Yeah.
This is not the first time this has happened. In the 1830s, Illinois went into the internal improvements industry big time, spent millions of dollars, which at that time was a lot of money, of taxpayer money to build railroads and canals and everything, and the railroads and canals didn't get built, and Illinois went bankrupt, and it held a constitutional convention in 1847, I think it was, and and the Constitution they produced at that convention was fantastic. It said no spending on internal improvements, and and corporations shall be private, not run by the government, and those few that are run by the government can exist only where private corporations can't do the improvement. So once the cold hand of reality slapped them down, they saw the light of day, but it's going to take that again, I think.
So my view is what Tim is saying is that the state will have to endure a bankruptcy before anything will happen. That's exactly what's happening in Puerto Rico. That's what happened in Detroit. I think the state is sort of at the bottom of the list on this. California at least has some growth industries so that it could put it off a few years longer. New York's a little bit better on the pension fund. I don't think New Jersey is going to go out under at least so long as, well, if they get rid of Chris Christie, it improves the chances of anything happening good. But I do think, in effect, that this state is probably, in terms of exposure to losses, number one on the hit list, and I think that bankruptcy is going to be the inevitable answer, at which point the political processes will take a very different turn. So everybody here pay very close attention to what's going to happen in Puerto Rico, and I can assure you, having done a little bit of work on that case, is that the scrambling of priorities as you go into bankruptcy amongst the creditors will create two tangles. One is how much do you owe in aggregate, and then two, which of the various creditors get priority of which one. Because if you think that you know what the priorities are in a secured arrangement and so forth, it's so complicated. Every state is different, right, as you said at the beginning, that's a real trouble. Yes, sir.
So my understanding is that bankruptcy is exclusively a federal jurisdictional matter, and the current federal bankruptcy code has no chapter that allows state governments to go bankrupt. So I'm not sure what your reference to our state going bankrupt is referring to, other than an ordinary insolvency and a default situation.
Well, it might go to that, but my guess is if you actually get to the edge, I think it's easier at the federal level to amend that particular statute so as to do it. And what I would recommend is you take whatever the provisions there are in the Puerto Rico situation, use that as a template, and then ask yourself whether or not there's some variation that you start to need. My guess is probably you want to do none. That is, what you really have to understand is that speed is much more important than elegance in dealing with this kind of situation.
But with the changing Congress and the White House, isn't the window perhaps brief to amend the bankruptcy code to allow creditors to throw this state into bankruptcy and allow a federal bankruptcy judge to restructure the pension liability without having to deal with Springfield or the voters of this state?
We understand that that's fine. The problem is we have a president with some kind of an attention deficit disorder from time to time. And so unless you could get this in a 15-second spot on one of the morning shows, I don't know whether it would be there. Essentially, the secret for working at the federal level is to try to work through the Congress and then try to work through everybody in the office of the White House by trying to keep this thing off the desk of the president. I mean, this is not meant to be high praise, but I think it's an accurate account of the prospects of success. Sir, did you have a question? Yeah. No, you first. You were handling it.
Glancing through the introduction to the book, I noticed that one of the authors says that there's no way to make any progress through the Congress in order to get these kinds of relief because the other states will not want to take it upon themselves to help Illinois out.
He may be right. They're not helping Illinois out, I think. I think they're helping themselves out. Look, let's you put it this way. If I were to go there and make the plea, I would say, look, either you allow the state to go into bankruptcy or you're going to have to give some kind of a federal bailout, which will come out of yours. And so you're better off. And then the other thing that I would want to do, which actually kind of helps Illinois a bit, is I think the Trump short tax proposal, which for the most part is pretty good, and said we don't want to allow deductions for state and local taxes against the federal government. Illinois, at least on the income taxes, a low tax side, they may do a little bit well on that particular thing. So look, when you're throwing Hail Mary full of grace, the fact that there are insuperable obstacles simply means, hey, business as usual. You have to face insuperable obstacles going everywhere. Sir, did you have a question?
You're actually going toward my question, which is that, every state around us went red, and if the...
That's Republican red as opposed to communist red, right?
It gets confusing.
Yeah.
Yeah, I wonder about that. I love it. If that actually goes through the way we think it kind of looks like now, and we don't, could that accelerate leaving of capital and human capital, and could that push us closer faster?
Look, my view about these things is they're never linear processes. What happens is they start like this, and then what happens is you have a run for the exit. This is like a bank run. And it's not just a question of people leaving. That's what people sort of misunderstand about this. It's you're Caterpillar, and you can put up a new plant. You put it up in Illinois, and you go across the river into Iowa or into Indiana. Answer is you do the latter, because you don't want to mess with this kind of stuff. So expansions don't take place. New entry doesn't take place. Some businesses shut down. And by the time you're done, what happens is you can't reconstitute. Let me give you a kind of a simple number. You know, everybody says, oh, we added in the economy 400,000 jobs this last month, right? That's an absolute falsehood. What we did is we added 4 million jobs and lost 3,600,000 jobs. That is, the economy is much more dynamic. And that's what takes place at the general level. When you look at the state level, what you realize is that the losses are going to be internal to this state and the gains are going to be somewhere else, and so there'll be much more volatility than the national numbers will suggest.
You are all welcome to Arizona. Very pleasant winters.
Yeah. Yes, sir.
So why, as you're listening to this, you're not painting a very pretty picture. And again, we did it to ourselves.
Well, I mean, never use the fallacy of composition or should not be brought upon my head. I did not do it to myself, and I've been a resident of the state for 45 years.
Why are there no consequences in the $20 trillion debt we have federally? Why are there no consequences or thresholds in the government that say you can't be more than 20%, or just like they put in for the banks right now, that you have to be solvent 30% or 40%. Why is it that these governments are allowed to dip into pensions, not pay it, Social Security, whatever it may be? If we have these laws, just like we were supposed to have about
sovereign immunity,
what consequences are if they don't? The only people paying for it is the citizens of Illinois.
Well, I will tell you a little story, okay? Since I'm actually teaching banking and have gone through this stuff, I had a secret meeting with 50 people with Chris Dodd, and I asked him, what are you going to do about the Fannie Freddie fiasco, right, with Dodd-Frank? He said, gee, we never had time to get to that. $180 billion. These people will always beat up on private firms first, because it's more fun than beating up on themselves. And until you essentially have a catastrophe, nobody's attention will be attracted. And so what happens is there are two definitions of insolvency. Definition number one is you can't pay your bills as they come due. Illinois is very shaky on this front with 9-month delays. But the other one is that your net assets are far below your net liabilities, and Illinois is so far in the red that essentially the other red, not the red state, not the communist red, the red state, right? That they can't get out. The latter tends not to trigger immediate action. It's only the form. And so when it turns out it becomes acute, then we will start to see it. But as best I can tell, unless you can develop something like a bankruptcy option, it won't work. You can take an insolvency procedure and sort of gussy it up as they did with the railroad reorganizations in the first part of the last century. And maybe that's what's going to happen. But that's going to be done by Illinois courts under the supervision of the Illinois Supreme Court.
Let me add to that. There are state constitutions do have limits on how much debt they're allowed to incur. They all go ignored, of course, and are violated for a number of reasons, not just sovereign immunity, but lack of standing problems and other reasons. Like courts will look the other way, and there's always ways around them. But as a result of the terrible economic catastrophes of the 1870s and the 1830s, state constitutions were amended to include these provisions. California's is, I think it's $200,000 of bonded indebtedness is the total amount. And of course it gets ignored and violated, but one of the reasons it gets ignored is because people don't bother suing.
Yes,
people don't know about it and they don't sue over it.
I can tell you exactly what happened to our pension money. Our pension money was stolen out of our funds by Richard M. Daley to pay for other objectives whenever he saw fit, okay? Not only that, when he stole our money, he quit funding our pensions, and they're still not getting funded to this day.
Well, what do I say is the tragedy that we have today is that there are so many victims and so few heroes. What you said is exactly right, and the reason I suggested that you should have had a defined contribution plan is you would have been administering the own plan yourself. This was the colossal mistake that was made 40 years ago. And remember what I said, I don't want to wipe you or anybody else out. I just think that what happens is you have to share the misery and share the mischief, because there isn't enough to go around. You can't give the creditors a 100% haircut and hope to keep going. You can't take current employees and tell them they get paid nothing. So what you need to do is have somebody who will do this. I'm going to quote a lawyer, and we're going to end on this note. A lawyer whom I met when I started the teaching, her name was Hermione Brown, and this is what she said to me when I was a young man. She said, Professor Epstein, she looked at me with incredulous eyes, she said, you could always tell a good deal because everybody's happy. And she said, you could always tell a good settlement because everybody's sad. And that's essentially the state that we are in the state of Illinois.
As per Scott's question earlier, who's held accountable?
At this particular point, the dead.
With that, thank you all for coming, and thanks very much to our panelists for this excellent